Hello everyone, good morning. I'm truly honored to serve today as the moderator for the second panel of the Oxford Arbitration Day, which focuses on ethics and international arbitration. First and foremost, I would like to thank Ana Carolina, André, Grace, Christian, Xuan for the kind invitation to be here today. And now just starting with our topic and the introduction of our panelists, I should say that it's undeniable that nowadays arbitration has emerged as the preferred method for resolving complex international business conflicts. The numbers of arbitrations don't lie about the increasing growth of the use of this method to settle civil and commercial disputes worldwide. And the essence of the international arbitration is that it brings together parties and counsels from different backgrounds, including different legal systems and cultures. So on one hand, international arbitration stands as a neutral arena where parties can expect to be heard and understood without prejudice to their origins. On the other hand, international arbitration presents challenges when it comes to the interpretation of ethical standards that are crucial to the application of arbitration rules. To discuss this hot topic, we are lucky to have 4 distinguished arbitrators, legal counsels, and representatives from arbitral institutions coming from different countries and practicing law in different jurisdictions. This diversity will enable us to explore multiple perspectives stemming from the same ethical issues in a Q&A format. So let's introduce our speakers. We have here with us today Adriana Yuson, who is the Director and Head of Singapore International Arbitration Center, where she leads and oversees activities in North and Latin America. Maria Claudia Prokopiak, who sits as an arbitrator with extensive experience in international arbitration. She began her career at the ICC International Court of Arbitration in Paris, and later worked for 10 years in Paris and London as counsel, representing clients in both commercial and investment arbitrations. And currently, she's a partner at Prokopiak Arbitration. Monty Taylor, who is a partner in Arnold & Porter's International Arbitration team in London, who also serves as adjunct professor of public international law at Pepperdine University and holds a faculty affiliate position at Queen Mary University of London Schools of International Arbitration. And finally, Osma Huda, who is a partner at Gibson, Dunn & Crutcher in London office, representing clients in international arbitrations from a wide variety of industry before arbitral tribunals, including the ICC and the LCIA. To kick off our panel discussion, I will begin by posing a question to Maria Claudia. Do you believe that arbitration is currently facing an ethical crisis? And if so, what are the underlying reasons for that perception?
Thank you, Mariana, and thank you to the organizers of the Oxford Arbitration Day for the invitation. It is a great pleasure to be here. Is arbitration undergoing an ethical crisis? Now that I've just been informed that this talk is being recorded, I will definitely try to refrain from giving a yes or no answer to that. But I would like to just share some thoughts with you that I would invite you to keep in mind throughout our discussions. So obviously, when we think about the ethical values that underpin international arbitration, we think about independence, we think about integrity, we think about trust. And for this, it is often said that ethics is directly related to the legitimacy of arbitration as a means of resolving disputes. So when we think about an ethical crisis, what we are really talking about is a legitimacy crisis. Now, as we all know, the very existence of arbitration is based on two pillars. On the one hand, we have the domestic laws that allow private parties and states to opt out of the court system and choose to resolve their disputes through arbitration. And on the other hand, we have the international enforceability of arbitral awards, guaranteed mostly through international instruments as the New York Convention. So in a nutshell, if we are allowed to arbitrate, if arbitration exists, it's because states allow us to arbitrate and then help us to enforce the outcome of the arbitration. Now, what happens if that state becomes dissatisfied with arbitration? And I am not talking here about governments, I'm talking about the population as one of the components of the state. Now, back in 2001, the late Johnny Vidar gave a talk about ethics in international arbitration, and he defended the need for ethical guidance in international arbitration. And when he was addressing the lack of rules of conduct for lawyers appearing before international arbitral tribunals, he mentioned that these situations could easily breed procedural unfairness in the particular case. And it matters generally because it attacks the integrity of the system of international arbitration. Without practical guidance for counsel, the system of self-policing may become impossible, and there may be a gradual deterioration in the standards of legal professional conduct. The international arbitral process would then be brought into disrepute, and once its good reputation was lost, it could take decades to rebuild confidence. So now, 20 years on, is this where we are? Is international arbitration in disrepute? Should we be trying to rebuild confidence? I would argue that maybe not in disrepute yet. I think we've come a long way from the ethical no man's land, as arbitration was once described. But I also think that when we see, for example, ISDS being described at the UN General Assembly as an unjust, undemocratic, dysfunctional process, when we have the Commercial Court in London, as we will discuss here today, recently questioning whether arbitration is the best forum for cases involving states, large amounts in disputes, questioning whether arbitration is more vulnerable to fraud, for example, I think all of that should give us pause. And we may or may not agree with these opinions, but we have to listen to them. The worst that we could do is hide our heads in the sand with the hope that this will go away. This is not going away. And I think that if we don't do it, if we don't try to understand where this apparent dissatisfaction is coming from, and if we don't try to address these ethical challenges, then it's only a matter of time before political actors will step in and regulate on a process that they do not fully understand, which would gradually result in the destruction of the benefits of arbitration. And this is not a theoretical concern. Unfortunately, this is exactly what seems to be happening in Brazil, my country, just to give one example. So apparently arising from a concern with respect to arbitrators' conflicts of interests and alleged breaches of the duty of disclosure that gave rise to some annulment decisions that were highly publicized, we currently have a very questionable, in my opinion, bill under debate in Congress that, if passed, could significantly alter several provisions of the Arbitration Act and result in a serious setback for arbitration in the country. And we also have a lawsuit before the Supreme Court questioning the constitutionality of certain aspects of the Arbitration Act. So without being too pessimistic about it, and that's not the tone that I would like to start this conversation, I guess my point is, and the question that I would like to put to you all is, are the stakes too high for us to keep trusting on our self-regulation abilities? I'm not sure, but I guess we will see what conclusions we will reach here in this panel. Thank you.
Excellent. Thank you, Maria Claudia. of course, this is, I think it was a great kickoff with a very sensitive and hard question. So I would like to open to the other speakers if they want to share with us a different perspective or if they agree with Maria Claudia's position.
No one wants to talk about a crisis.
Well, perhaps maybe if I go next, because I think some of what I'm going to address will maybe show us slightly. I'm a bit more optimistic, Maria. So shall I take my? Do you want to take my topic next?
The next topic. Okay. We don't want to talk about crisis. So
not yet, anyway.
Not yet. So, Ozma, which ethical rules apply to arbitrators and counsels?
Yeah, so I think this topic does follow on from Maria's introduction, because I think we are a long way from the ethical no man's land. And I think rather than addressing the question in terms of what applies, I might talk about sources of obligations, because I think there are plenty. So if I start with arbitrators, I think there are three, I would say. So there's the domestic legislation of the seat of the arbitration. So the English Arbitration Act has a provision for arbitrators to act with impartiality. Doesn't have an obligation of independence, and I'll come back to that. And then there is a body of case law which sets out how that is to be interpreted and when there's been a violation, for example. So that's one source. We are seeing the growth of ethical codes of conduct for arbitrators. So we have the IBA guidelines on conflict of interest. We have IBA rules of ethics in international arbitration for international arbitrators, the SEAC code, and the very new anti-trial code. So again, there is a move towards codifying some of this, which I think is a recognition of the importance. And then, of course, the arbitral rules have certain provisions. So I think everybody recognizes the importance of it. Some of the issues that I think are arising from these different set of rules is when different words are used, does that mean different things? So the absence of independence in the Arbitration Act, what does that mean in practice when you have rules or a code of ethics that requires both independence and impartiality? Is that an avenue for challenges? Does it become very technical? Does the relationship in legal traditions, does a connection between arbitrator and parties matter or not? So these are some of we are trying, but there are still issues that arise from that. And then just touching briefly on, for counsel, I think it's a slightly different picture. Practically, I suspect for most people, they would look to the rules of the jurisdiction in which they're licensed. That would be my first go-to. But those rules are built around the legal traditions of the jurisdiction, so they don't translate very easily to international arbitration. And so what I think we see is almost like an issue-based approach to rules to address that. So the IBA rules on the taking of evidence was an attempt to level up is maybe the wrong word, but certainly create some standards for disclosure and document requests and when you can withhold documents. But of course, that won't tell me as counsel what's my obligation to advise my client on preservation, what's a reasonable search, what if we don't produce documents? And so there was a recognition of that gap, which led to the IBA guidelines on party representation. Now, these are all contractual. You have to agree to follow them. And that does touch on some of the issues that I have just described. So, again, there is a recognition of this issue. I think there is a movement to trying to create some general standard. I think where the gap remains is enforcement. The strength in the rules really does depend on how they will be enforced. We all have our bar councils, and there isn't quite that equivalent. So that remains a topic of I think, interest and focus for me.
Excellent, thank you, Ozma. I think Monty has also an additional view on the council perspective, if you want to add on.
Thank you. So this is specifically with respect to privilege, which I know everyone's thrilled to talk about, but it I think invariably comes up in the context of these discussions about ethics, and is such a great and commonly seen example of where you see these asymmetries develop because of the perhaps varying approaches or obligations that bind the lawyers on one side or the other. And from a practical perspective, we see in the IBA rules there's this reference to standards that would be applied by the tribunal, but it doesn't in fact actually identify that standard. So to Osma's point, it's very difficult to know what you're going to get within a case. And then you find, again, within the IBA rules, there's this reference to expectations of the parties and their advisors when the communication was made or the advice given. And that becomes almost a basic conflict of laws principle where you're looking back to the expectations at the time. This perhaps goes to a slightly different question, which is how this is dealt with in practice. But I have seen, and maybe others on the panel have as well, tribunals not engage as closely with the granular question of what the parties were expecting, what the lawyers were expecting when the communication was made, but rather index the entire discussion to the first principle, which I think it's in 9.4a, which is protecting confidentiality of a document or communication created or made in connection with and for the purpose of providing or obtaining legal advice. Sorry for the quote, but it effectively tethers the analysis to a purposive question, which I think has some form of I think built-in bias to an extent to certain legal systems that looks at the purpose of the communication or the document in determining whether it is in fact privileged. So tribunals will sometimes use that as your catch-all of this is what is privileged and this is what is not privileged, rather than looking to what, say, a lawyer from Malaysia or a lawyer from Panama or a lawyer from the UK may have meant or expected when they originally created the communication or had the discussion, made the document. And this comes to this broader question of whether difference should be respected and upheld within international arbitration, whether it is the lifeblood of what we do as flexibility, party autonomy, legitimacy, or whether we should be searching for some form of homogenization, harmonization to create a single rule, for example, that can then apply in arbitrations, you know what to expect. And we know that the IBA has put in place a task force to consider that very question, whether there is, whether it's problematic or whether it's possible or desirable to have uniform rules on privilege, and that work is underway. But I'm very excited to discuss that question about the instinct to, or the desire to create binding or harmonized rules versus the diverse and different backgrounds of the participants and lawyers within arbitration, and which is preferable, if either.
Excellent, thank you, Monty. I don't know if any other speaker want to discuss this topic of harmonization. I think when it comes to privilege, it's a very hard issue to propose, but I don't know if you want something to add something on this topic. Okay, so let's move on to our next topic that has a certain relation with this discussion about Council's role in these ethics standards in international arbitration. That is the topic of guerrilla tactics. So, Maria Claudia, how do, in your opinion, different standards of ethics in international arbitration impact the concept of guerrilla tactics?
Now, when you first put the question to me, when I first started thinking about this question, my first thought was they don't. You know, different standards of ethics in international arbitration should not impact the concept of guerrilla tactics, and that's because, in my mind, there is a clear distinction between, or should be a clear distinction between these concepts, because if someone is acting in accordance with his or her ethical rules, then by definition, this cannot be a guerrilla tactic. A guerrilla tactic is a conduct, is a behavior aimed at obstructing the proceedings, and standards of ethics should be the opposite, should be what guarantees that lawyers conduct are guided by honesty, by good faith, by integrity. But as we already heard a little bit here from Osba and Monty, in international arbitration, different standards applying to different lawyers in the same case create all kinds of challenges. And we can think of a myriad of textbook examples. For example, the systems that allowed witness preparation before the hearing versus those that don't. The system that do not require the production of unfavorable evidence versus those that do require the production of documents if responsive to legitimate requests, even when they are unfavorable, and so on and so forth. So I guess the question then becomes, for example, what do you do if a party fails to comply with an order for the production of documents because they truly believe they have the right not to produce evidence against themselves? And obviously, in real life, you would consider several other circumstances before reaching the conclusion that someone's behavior was intended to disrupt the proceedings. And here is probably where the difficulty lies, because it seems to me that it is on the intention that you could draw this distinction, but intention is not that easily proven. So in principle, sanctioning someone for acting in accordance with his or her own ethical rules, or even holding that behavior against them, could be questionable. And that is why, as much as possible, these issues, especially when they relate to the production of evidence, which seems to be a bit easier to deal with in light of all of these sources of soft law that we have, as much as possible, they should be dealt with up front. But more often than not, they aren't. And I think this is because we seem to have this idea that lawyers participating in international arbitration are abiding by subjective, internationalized versions of their own rules of ethics, which are sufficiently similar in content so as not to present significant challenges. And to a certain extent, that might be true. I think it would be fair to say, for example, that virtually every national code of ethics out there would condemn the use by a lawyer of false evidence, for example. But again, issues are not always that black and white. And I think until we have a standardized set of rules with international reach applicable to every individual appearing before arbitral tribunals, I'm afraid this will always be an issue, and I don't think we have an optimal solution for that yet.
Thank you, Maria Claudia. Osma, Monty, I don't know if you have anything to add from the council perspective. Yeah?
Sure. Well, I'm always interested in references to guerrilla tactics because it seems to build into the concept an idea of bad faith or doing something for that advantage. And perhaps I'm a little naive or optimistic, but I always feel that bad faith is usually a good faith application that results in an outcome which is not necessarily desirable to the other side, so you assume they're out to get you in some way. I mean, witness coaching, to take one example, of course, not permitted within the UK system and multiple other systems, but within the US system, you'll find that it's actively encouraged to an extent. So you'll have these hearings where one witness will come across as quite underprepared and perhaps even more candid, whereas another will come across as extremely polished, but perhaps not benefit from that. So whilst you could argue that that's a guerrilla tactic in play, as in one side is taking advantage of different ethical norms that apply to it versus the other side, I think the tribunal can see a polished, coached witness versus one who perhaps is not coached or polished in the same way and determine what weight to apply to the evidence that they give. But that's just a general point about the nature of guerrilla tactics. And from my perspective, I tend to see most counsel operating with the greatest of integrity and not seeking to win a case through breaches of their own ethical rules or otherwise take advantage of differences in it. And it's simply a function or a feature of the system that there are going to be these differences there, and it's for each matter to try and work out how that plays out. And I'm also fascinated by how tribunals react to this. And one example and perhaps this is more of an evidentiary rule than an ethical one, but within the UK system, I'm an Australian, similar system in Australia, when you're cross-examining a witness and you intend to put a proposition in closing submissions that adverse to that witness's or that party's interests, you have to put that proposition to the witness to give them an opportunity to respond. So I put it to you, Mr. X, that you are being untruthful in that evidence. And that is a rule in the systems that I mentioned. But some tribunals who aren't familiar with it can be deeply offended by that because you're accusing this witness, this poor Mr. or Ms. X who's turned up to give evidence and help the tribunal, of being a liar. And so this ethical/evidentiary rule, it's an evidentiary rule, but I think it has flavors of ethics involved in it. But you can see tribunals reacting negatively to that because of their own cultural or legal background. So perhaps not a question as to guerrilla tactics, but just an illustration of how compliance with your own ethical or evidentiary obligations can have unintended and perhaps negative consequences.
Excellent, thank you, Monty. I think your answer touches on a point related to the interpretation of rules or conducts of the parties or the arbitrators. That brings us to our next question to Adriana, related to arbitrators' disclosure duties. That also is an issue that we have discussed. Firstly, what is the difference? It might not have many difference because the obvious is that arbitrators should disclose all the information that are necessary for the parties to evaluate the appointment. But we found out that there are relevant distinctions, and in Brazil in particular we are seeing a broad discussion on this topic. So Adriana, would you like to share with us your opinion on what are the main challenges related to arbitrators' disclosure duties in international arbitration?
Thank you, Mariana. And before I respond to that question, I wanted, two mics. Thank you. I wanted to greet everyone. Very good morning. I'm so delighted to be here with all of you and to share this panel with my esteemed colleagues. I want to thank, of course, the Commercial Law Center of University of Oxford, the University of Oxford International Arbitration Society, Arbitration Channel, and Educa Foundation. So to answer Mariana's question, for me, I think the challenge for arbitrators is really what and how much to disclose. Because the answer to this, and like what you mentioned earlier, might differ from institution to institution and from seat to seat. So, for instance, in Singapore, the standard is justifiable doubts. So there should be justifiable doubts as to an arbitrator's independence and impartiality for an arbitrator to make a disclosure. But say in the US, the standard is evident partiality. We see in UNCITRAL model law, the UNCITRAL arbitration rules and even the SIC rules, again, the standard uses justifiable doubts, but there are some institutions, for instance, ICSID, where the question asked is whether there is a manifest lack of the required qualifications of an arbitrator. So these standards vary in terms of disclosure. And then the standards itself lends itself to different interpretations. So for instance, justifiable doubts. So there are two schools of thought. The first is that there must be a subjective approach. So the lens that is used is that of the parties. So whether the parties feel that there is justifiable doubts as to an arbitrator's impartiality or independence. Meanwhile, another school of thought says that it should be an objective standard, which means that the perception should come from a third reasonable party. So again, there's differences in the application of standards. Now, another thing that, I'm speaking based on my experience in an institution, when we approach arbitrators, the other thing that we recommend is for arbitrators to look at the IBA guidelines on conflicts of interest when they're deciding on what to disclose. But even then, that can also be tricky because sometimes tribunals and courts do not really apply the IBA guidelines. So for instance, there's a principle in the IBA guidelines that provides that the fact of non-disclosure should not be in and of itself proof that there is impartiality or a lack of independence, but a case in Brazil, I think we discussed this case that was similar actually in its fact pattern with Halliburton versus Chubb. So in Halliburton versus Chubb, consistent with the IBA guidelines, the arbitrator that did not timely disclose that he was appointed by one of the parties in a current case in another case, the fact that he did not timely disclose that, the Supreme Court of the UK said there was a breach of duty of disclosure, but it looked at the nature of the disclosure to say that the arbitrator is not impartial or is independent. But in a similar fact pattern in a Brazilian case, the Court of Appeals, I don't think it reached the Supreme Court yet, addressed that issue in a different manner and said that actually the decision was made solely on the fact that there was non-disclosure, regardless of the nature of the disclosure. So see, there might be some differences in the application, even with guidelines that are almost universally accepted. So I think, for me, I think with this question, for us in the institution, we encourage broad disclosures. Arbitrators should be looking at the different laws that might apply to them. The different institutions would particularize what standards are required. So these are the things that they should be looking at when making disclosures.
Thank you, Adriana. Yeah, indeed, we are. Do you want to comment on Brazil? Yeah, I was just going to mention that we are facing in Brazil a broad discussion on the topic of what should be disclosed by arbitrators. Maria Cláudia mentioned the project of law that was being discussed in Brazil, and we are seeing many cases in the Court of Appeals in São Paulo, for example. So I will give Maria Cláudia the floor to talk on that.
Okay, so just very briefly, one general comment. I think the first thing that I would like to say is that we have to be very careful in identifying what are the standards for disclosure and then what are the standards for accepting a challenge. So disclosure, arbitrators should basically disclose all of those facts or circumstances that would call into question their independence, impartiality in the eyes of the parties. And then when we go to the standards for accepting a challenge, it will indeed depend on the national law, and Adriana mentioned those quite well. I think the problem in Brazil is that we do have a decision from the Superior Tribunal of Justice that actually said that the lack of disclosure is in itself a violation of public policy. And that's where the danger lies. So they did not analyze the circumstances underlying that lack of disclosure. They simply, reached the automatic conclusion that because a disclosure was not made, the award should be annulled. And that decision, which comes from the Superior Tribunal of Justice, has been followed by a series of other decisions from lower courts, which is what is, in my view, creating the problem. And I think that it should never be accepted in any system, in my opinion, this automatic relationship that is done between lack of disclosure and lack of independence or impartiality. You need to look into what are the circumstances that were not disclosed to then reach the conclusion that the arbitrator lacked independence or impartiality. And I think that that is the biggest challenge in Brazil now, and in the state of the case law in Brazil right now, is that judges are not taking that second step. They are literally stopping on the lack of disclosure.
Yes, indeed, and I think that what is the most difficult part on this discussion that we are facing in Brazil is that we don't have objective criteria to apply, which should be this objective approach from a reasonable third party to conclude that this should have been disclosed, and because it was not disclosed and it's a relevant information that the parties should have received before, then the arbitral award should be annulled. But I would like to hear also from Monty and Osma if you want to add some thoughts on UK perspective.
Yeah, I mean, I think, you know, there's certainly, the case said that the lack of disclosure does give the appearance of bias, but obviously it would look to the circumstances as well. It isn't this automatic. But a connected issue, it seems to me, is what is it I have to disclose? This is another, not to add to the myriad of issues, but is it based on my actual knowledge, or is it after a reasonable inquiry? And that's another topic that I think, in addition to how much should I disclose, it's how much should I investigate and uncover first, and then what of that should I disclose? And the Law Commission recently looked at this in the context of the Arbitration Act and favoured actual and then a reasonable inquiry type disclosure, which I think just adds to some of the issues that we are talking about today.
Just an additional layer, and I'm traipsing on the ground that I think I saw Dr. Conway Blake walk in earlier. I'm not sure if he's here. But he spoke very eloquently about these points at a previous panel on a similar issue. But the question of whether the experience of ISDS and the additional concerns around double hatting and general backlash against that system is affecting the ways in which arbitrators approach disclosures, and in turn, what is the standard for either manifest lack or justifiable doubts? So that question of what is an objective standard, from my perspective at least, does seem to be changing, and as it should, in the sense that it should be an assessment of what a reasonable person, what the market, what an informed observer would consider to be illustrative of a lack of the requisite qualities for an arbitrator in that case. But as we've seen that additional controversy around ISDS increasing, we're seeing in turn, and perhaps a greater desire on the part of arbitrators to get out in front and disclose more, issue transparency statements, not just in the ICS context, but also in the commercial context. And then you're seeing decisions which arguably are finding a lack of the requisite qualities that you may not have seen 5, 10, 15 years ago. And think of cases like the ISA case and the Lufthansa case. These are I would certainly not say they're extreme examples, but they're certainly not examples that I would have expected to see result in a successful challenge only perhaps even a few years ago. So you're seeing a change in attitudes, which I think is in turn affecting the standard potentially, and also the attitude of arbitrators. But that's just my experience from having seen how arbitrators approach this, and indeed informed by Dr. Blake's very helpful and learned comments in a separate discussion. So I'm curious as to whether others on the panel have seen that change in approach to disclosures as well.
Thank you, Monty. I think your point touches on our next topic related to what is changing with regards to the standards that are expected from arbitrators. And in this sense, I would like to hear from Adriana, how do you think, in the perspective of representative of an arbitral institution, that an arbitral institution should contribute to these challenges related to conflict of interest, considering these changes that we are seeing the last years?
I think ultimately it's providing clarity. It's hard because of the different standards, but I think every institution would take a certain position. So for instance, with SIC, with our code of ethics, we clearly provide that we use the objective test or standard when we're looking at justifiable doubt. So at least that's clear enough in our code, and then we provide certain examples and ask the arbitrators to make certain disclosures. So one is clarity. I think the other thing too is that for institutions, we want to encourage, like I said, broader disclosure. And in order to do so, we need arbitrators to trust that institutions would know how to handle these disclosures. Because often I think what we hear from arbitrators in the market is that they say, there's a fear that over-disclosing will submarine their appointment. And this term of over-disclosure actually shouldn't really be an issue. Because for us, or at least for the institution, when an arbitrator makes a disclosure and accepts an appointment, ultimately this arbitrator is saying, look, I am independent and impartial, but I'm making this disclosure out of an abundance of caution, and that's why I am accepting this appointment. And so it is now up to the institution to deal with these comments. So for instance, I mean, for us, we take a very nuanced approach with these comments. So say, what if the nomination came from a party, a nomination of a co-arbitrator, and an appointment of a sole arbitrator, maybe, or a presiding arbitrator because the parties did not agree? Would the institution treat these kinds of nomination or appointment similarly or differently when a disclosure is made? So generally, people would say naturally it should apply the same standard for uniformity. But with us, with SIC, we treat it quite differently. So for instance, if a party makes a nomination of a co-arbitrator, this co-arbitrator makes a disclosure, it is unsurprising that the counterparty would make an objection. And so how do we deal with such objection to a disclosure? So we look at the circumstances of the case, but more often we would rather respect party autonomy and leave the party making an opposition to go through the challenge process to make sure that the opposition is serious enough. But on the other hand, if, say, the appointment is institutionally made, so for instance, if we appointed a sole arbitrator because both parties are unable to make an agreement, or if we appointed the presiding arbitrator for the parties, in such a case, we apply the standard a bit differently. So if there is a disclosure, we look at it very carefully, and then we often look at or proceed to another arbitrator that is unburdened with any disclosure, because the ethos really of SIC is to make sure that appointments are, well, lily white and there won't be any issues. So that's another contribution I feel that institutions can make in the challenges of disclosure. So clarity, and then instilling trust that disclosing possible conflicts will not tank or submarine their appointment.
Thank you, Adriana. I would also like to hear Monty about, if we may say, the role of counsels with regards to conflict of interest, even though they are not institution, and we have already talked about a little bit how counsel should recommend clients on certain ethical issues that might be relevant for the transparency and the arbitral proceeding. Do you think that counsels have a specific role, and how do you deal with the conflict of interest and these changes that we have been talking about?
Do you mind if I ask a clarification? Do you mean conflicts of interest as perceived within the tribunal or for counsel themselves?
Of the tribunal.
Well, how does counsel deal with conflicts of interest for the tribunal? Well, that is very much a matter for each counsel, I'd say, carefully. And you see enormous divergence, I would say, within the industry as to how counsel approach that. It used to be, or at least at some firms, and I won't suggest which ones I've been involved in where this is the case, but there is almost an allergy to a challenge in the idea that to do so, particularly if it's unsuccessful, you pollute the tribunal against you, and you taint the waters, and it becomes this terrible fact within the case, and you're never going to be able to win that arbitrator back, even if it is, as it usually is, the other side that's appointed the arbitrator, and you don't expect to have that vote necessarily. It just creates a bad environment, unless you have something which is like truly manifests in the sort of ICSID standard of conflict. But when you look at other counsel and other firms, you see a much lower tolerance for any sort of perceived conflict. And I would say generally within the industry, as I mentioned beforehand, you're seeing a lower tolerance for perceived conflicts and a greater comfort level perhaps with filing challenges, and on issues that wouldn't, I would say, would have made the cut for a challenge, say 10 years ago, and even issues out on the green list or outside the green list or whatever color in the traffic light system can be used to justify a challenge. You see some counsel will challenge every arbitrator on a tribunal from time to time. So it's difficult to be definitive in terms of an approach that counsel take, because it's very much a matter for each lawyer, each firm, each client as to how to approach it. But at least from my perspective, I tend to skew towards taking care with these things and not filing a challenge that I don't feel has a strong prospect of succeeding for fear of that consequence.
Oh, can I add something?
Yes,
So to Monty's point on challenges, so I guess apart from that fear, I was also thinking, based on the statistics that we have on challenges, whether these sort of differences in standards and, standards of disclosure and ethics actually affects challenges. So for us, we have a caseload of about 400 every year, new cases every year, and then we probably only see about less than 5 challenges. So in 2022, we had 2 challenges, and only 1 was successful. Last year, there was only 1 challenge, and it wasn't, the year before that, 1 challenge, and it wasn't successful. And I say this, that there might not be really this really universal problem in terms of varying standards, because we see cases from over 100 jurisdictions, 6 continents, and they come from different legal backgrounds and jurisdictions, and it doesn't seem that the challenge process has been triggered, which I think is a good thing.
That's interesting, Adriana. Thank you for sharing this data, and perhaps some of these issues that we are discussing here appear in annulments. I don't know if Osma and Maria Claudia want to add on this topic or on the over-disclosure issue.
Not necessarily on the over-disclosure issue, but I wanted to make one quick comment that, I think you mentioned that maybe what's happening in Brazil comes from this idea that it's very hard to know what to disclose and what are the limits. And I'm not entirely sure I agree with that. I think we have several guidelines out there nowadays that help us in understanding, what we need to disclose. We have the institutions now providing for more rules of what they expect us to disclose. Obviously, it's impossible to get to a situation in which we would have, a closed list of circumstances, because we are talking about, human relations, and in the end, it's impossible to foresee everything. But I do believe that there is a fair amount of guidance out there. That doesn't mean that it solves all the issues, but I think that a second step, which we have seen being taken by some institutions, is making available and making public their decisions on challenges, because at the end of the day, the institutions are the ones making those decisions. If these things go to the state courts, we are talking about annulment proceedings, but not every challenge becomes public. And so having the institutions making this information more public, I think, is quite helpful then to define the limits of disclosure.
Yeah, and I think I would just add that is there such a thing as over-disclosure? I mean, I think transparency is important, and I think there is a real benefit in sort of a cards-on-the-table approach, precisely in a world where confidentiality is important. If you don't want an award later challenged, I think I favour the trust and I'll use the phrase over-disclosure. I'm not sure there is such a thing, but that's just my perspective.
Can I just add on that point? And I might be going to troubled waters here, but I would argue that there is such a thing as over-disclosure. And I'm not sure, for example, something that is really de minimis, or I saw this disclosure being made once that, my kid goes to the same school as the kid of counsel for the other side. That for me is over-disclosure. And the problem is that if we start accepting that everything needs to be disclosed and we go to that levels of disclosure, that then becomes a standard. And when those things become standard, they can create problems. So we think, there should be limits to it and we should disclose what is really relevant and important. But yeah, we could be, I think we could argue that over-disclosure in that sense is not beneficial.
I would like to add to both points that I agree. And disclosure, I guess what we're looking at is disclosure of still within the bounds of what is possibly that will give rise to justifiable doubts as to one's independence and impartiality. So arbitrators are also, of course, asked to, while we want, a broader disclosure to be very measured with the disclosure and made within the bounds of those standards that we seek. Of course, these disclosures and if challenges are made would have some cost and delay to it, and mindful of that. Arbitrators should be, so like what you said, going to school or kids going to the same school, or maybe an arbitration that happened 10 years ago, but then if that doesn't give rise to justifiable doubts of independence, then that's something that probably is outside that realm of standards that we're looking at.
Thank you all. It was very productive, this topic. I think we could move on to another sensitive issue that is related to ethics, that is corruption in international arbitration. So I will address to Monty this question. What do you think are the roles of institutions, arbitrators, and councils in this debate of corruption in international arbitration?
Thank you. So when speaking about corruption in the context of arbitration, you tend to find yourself talking about standards of proof and corruption on the tribunal, but most commonly, particularly in the investor-state context, looking at allegations of corruption in the making of the investment. And for my part, at least, I don't think that touches upon ethics in the same way as this panel is supposed to. So I'll address a slightly different point within it, which is the standards that counsel must comply with in setting out allegations of corruption. And this is something that I wasn't as familiar with before starting practice here in the UK, but at least under the old SRA rules, there are quite strict rules about the ways in which you can plead fraud or corruption. And specifically, you had to only plead it if there was material on its face that showed a case of fraud. And when you consider how difficult it can be to make out allegations of corruption and fraud, particularly in the absence or before document disclosure or production, I was quite surprised by the level at which that standard was put. And then you put it in the context of, well, let's say you have UK solicitors, English and Welsh solicitors regulated by the SRA in a case where they are against solicitors from a completely different jurisdiction that is not subject to that requirement. You could have quite different obligations applying to the respective counsel as to how you plead and how you deal with corruption and fraud allegations. I mention it because it does come up frequently, particularly in investor-state cases, and we've seen some quite prominent decision recently dealing with corruption, perhaps not specifically on the question of pleading, but it is an issue that is considered by counsel during the course of a case that may not see the light of day within an arbitration, because you don't know if something has not been pleaded, of course, but the lawyers have spent hours talking to their internal ethics guidance committee about whether they can make an allegation based upon the evidence that they have, and potentially one may not be made even if documents could come forward in disclosure that make out that allegation. So it's an interesting potential division between the ways in which certain ethical rules apply and how they may not apply in different contexts.
Thank you, Monty. I don't know if the others want to add some thoughts on this hard question.
I've invoked the Nigeria case if anyone wants to take this up now.
So I would move on to our concluding topic here before open to the audience for questions. And this question is directed to all speakers. So bearing in mind all that we have discussed here and these different legal and cultural backgrounds of practitioners, do you think it's possible to aim for a single ethical standard in international arbitration? Perhaps Osma, do you want to start?
Sure. I think it depends what we mean by the ethical standard. I think there are core ethical standards for arbitrators in council that are universally agreed. Impartiality, not to tamper with evidence, not to rely on fraudulent evidence. These broad concepts, what they mean in practice is informed, I think, by legal traditions and cultural norms. And for me, while you may be able to agree on the core concepts, the guidance that would come with that is where the variation lies. I think it would be a real challenge to codify that and standardize that. Is that something that the flexibility of arbitration should encourage? I don't know. I don't have the answers to that. And I think even if it were possible, I go back to the enforceability. You'd have to look at rules and how do you enforce them together rather than in isolation. But nonetheless, if you can agree some core principles, is there a downside to trying to distill those, to reminding all participants in the arbitration process of the importance of honesty, integrity, and other core values so that trust remains in the system? Maybe.
Thank you, Osma. Adriana, do you want to?
A universal code of ethics. Well, I think the arbitration community has been trying, right, for decades to fill this ethical void. And I wonder whether, and like Osma's indicated earlier, there's been a number of these codes of ethics out there. I wonder now whether it's becoming paradoxically a manifestation that there is no one universal code, because I'm not sure if it has been universally accepted. I guess the trouble there is outside of enforcement. That's one issue. Is also it's consent-based. So if a party representative signs up for additional regulation to itself, it's like, I don't know, asking a turkey to vote for Thanksgiving, which is timely. So because of that, it is quite difficult to foresee. But like what Osma said, I feel that certain principles are universal, such as honesty, integrity, professionalism, and most of these codes have what they've done. For instance, the Singapore Institute of Arbitrators has created this code for party representative is to crystallize that these are still expectations in an arbitration, and that because there's no one code, it doesn't mean that you can act in a certain way. But I also wonder whether there is some balance to be made in terms of promoting uniformity, but also respecting and recognizing the diversity that's inherent in international arbitration. So even with a code of ethics that is universally applied, party representatives are still bound by their own professional conduct. So if we want to even out the playing field to make sure that it's applied uniformly across, then it might be a situation where we're applying the maximum required standard of ethics for all. The other thing I want to mention, I don't know if you're familiar, so Cyrus Benson created a checklist in 2009. So what it does is that there's a checklist of issues where there might be some differences in terms of ethical practice. So at the start of maybe at the procedural conference, parties will discuss with the arbitrators which ones would they agree to apply. And maybe that can be a sort of a way of marrying the two. So having a standard code that has the basic principles that is universally recognized, and for those that are very controversial, then parties can come together to an agreement on how to deal with those things, such as privilege, witness coaching, or yeah.
Very interesting kind of minimum standards that we could perhaps idealize in international way, but we would still have space for different cultures and backgrounds. Monty, do you want to add on?
Yeah, so I think that's a really interesting idea. My initial reaction to your question is that I don't think it's uncontroversial, some of these founding tenets or things we can all agree on, but the difficulty lies in where we have these differences, and whether it's you are prohibited from talking to a witness before a hearing versus you're encouraged to do it, prohibited from providing certain documents versus you have to or you're criminally liable, or something to that extreme extent. And even avoiding the question of whether you can contract out of your ethical obligations, and I think that is a real practical question of if we're trying to develop some form of code that would apply over and above or instead of your national ethical obligations, or ethical obligations sourced from your national bar. And I think that is a very difficult question, as I mentioned. But even excluding that, is it appropriate to try and homogenize in such a way that you are naturally going to elide and exclude certain key foundational tenets of certain national jurisdictions and the way in which they have developed? And again, it comes back to the point I raised at the beginning, but any effort to homogenize naturally and has to exclude something, it has to resolve difference and elide difference to an extent. And is that something we should be aiming to do, given the nature of this system and the particular history and place, the culture and history of a jurisdiction that grows these ethical standards that applies to each of us in different ways, depending upon where we are in fact barred? So I think it's possible to put together some basic foundational guiding tenets, but I don't think that actually addresses some of the real problems that we've discussed here today. And frankly, I don't think we should be trying to do that, because I wouldn't want to lose that important difference in the way in which we all practice and the flexibility and autonomy that's present in the lifeblood of the system.
Interesting. Thank you, Monty. Maria Claudia, what do you think?
I think that when we talk about this, we are always thinking about trying to uniformize, different national codes and rules that exist out there. And the debate is still very much confined in this idea that, we have these national codes. And I think that maybe what we could be trying to do is trying to think about if there is something out of this, or if we could think about something that is completely detached from these national standards and codes. And maybe we could learn something from history in the way that international arbitration has developed. And I apologize for being a bit of a nerd here, and I'll have to take us back a bit in time to try to make my point. I think a good example is the role that the ICC played in the acceptance of the idea of a truly international arbitration, and the contribution of the ICC to the adoption of the New York Convention is well known. And at the time, the ICC was already pushing for this idea of a truly international award, which was not well received, and the concept of a foreign award based on, a national legal system was preferred and went into the New York Convention. And then it took decades for the ICC rules to allow tribunals to organize the proceedings without reference to any national law. I think it was only in the 1975 rules that we saw this. And what was seen at the time as a revolutionary innovation nowadays, became what we understand as arbitration proceedings. I think it would be, nobody would seriously argue today that arbitrators, should follow the rules of procedure of the place of arbitration, for example, unless they're mandatory. So to go back to the point that I was trying to make, I think that to be able to address these new challenges, this is the kind of innovative thinking or innovative ideas that we should be trying to aim for instead of being, limited by our national codes and national rules. So couldn't we imagine, for example, international arbitration institutions making a concerted effort to come up with a unified set of ethical rules that would establish the standard in international arbitration, and then saying, those individuals appearing before tribunals that are acting under the auspices of our rules must agree to comply with these guidelines. Is it possible? Is it doable? Is it a daunting task? Absolutely. Would it be easy? Not at all. Is it inconceivable? Maybe today, but in a couple of years' time, who knows? I just think that we really need to try to think about this issue outside of the box that we have put the issue in, and we have to start somewhere.
Excellent, thank you, Maria Claudia. I'm seeing that we are reaching our final time. I would like to open for the audience. I don't know if anyone has questions. Celso?
Yeah.
Yes, please.
Hello. Yeah. First of all, congratulate you for the brilliant panel. You've been very brave and honesty with all these difficult issues you just touched. And Maria Claudia, I have a question for you about the duty of disclosure, and any of you, please feel free to comment on that. You suggested, based on Brazilian law, and I think that will be in other countries the same thing, that the standard we have in Brazil is the just file of doubt. And you said that there would be decisions from the Brazilian Superior Court of Justice, obviously that I know them, saying that, well, if there's a failure, a breach of this standard, the consequence would be that the award would be void. And then what I understood you suggested is that we may need to have a second step, a second test, which is that let's see what the failure was. Let's see if it was substantial, because if it would not be substantial, the consequence should not be the award to be considered void. But as a matter of fact, and that's my understanding, just to see your understanding, is that if we raise this bar to say that, well, I don't care about what you have failed to disclose, because if you have failed, the consequence, voiding the award, would only take place if the facts that you failed to disclose would be substantial, would be a cause, for example, for lack of impartiality or independence. Wouldn't we be raising the bar by taking this step? Because what I understand is that if we raise this bar, no arbitrator will disclose any just file of doubt. We'll only disclose what may be a cause for a lack of independence or impartiality. So we'll be somehow saying that, well, if this is not important, maybe from a third-party eyes, this may cause a just file of doubt, and not disclose, because in the end of the day, this was not substantial. It may give you a doubt with regard to the facts, but if this will not prevent me from being an arbitrator, I will not disclose. So wouldn't we be simply raising the bar set forth by the Brazilian law by doing that?
Raising the bar for what exactly? For the duty to disclose, or for the grounds for, the standards for the annulment?
Let's give an example. Probably it's going to be easy. You touched the issue about, well, we have the arbitrator and the party councils, kids in the same school. Obviously, this will not even cause a just file of doubt. But let's put another example. We've been, as a counsel for the party who appointed you, we worked as co-counsels in a case. I think everybody in any test will see that, well, this may give rise to a just file of doubt. It doesn't mean that necessarily you'll be prevented from acting as arbitrator, but this may cause a just file of doubt. Let's assume you have failed to disclose that, okay? There will be a breach of the just file of doubt criteria of this standard. But the fact that we have worked together in one case may not be a cause for you to be prevented from working as an arbitrator.
But
So-
then because I didn't disclose, that would be a ground with the state of Brazilian case law today for annulment. So we are, at the end of the day, saying that a fact that we both agree that if it was disclosed would not give rise to an impediment for me to act as arbitrator, would then be an accepted ground for annulment. And that's where I think the difficulty lies. That's what I think we have to be very careful about. First, what is the standard for disclosure and what are the issues that we need to disclose? And the standard is not the same for disclosure and for annulment. So if we stop at the non-disclosure phase, we will annul awards because of the failure of disclosure of a fact that would not prevent me from acting as arbitrator. And that's where I think the problem is with the Brazilian case law today. I don't know if I...
Okay, thank you.
I think Manuel.
Very quick comment to your point, Sal. So we have to be careful that our conduct in the arbitration should not be guided by whether or not the award will be valid only. The arbitrators have a lot of procedural discretion that courts generally cannot question. And basically, the courts will not reverse. That's not a reason not to do the right thing. And besides sort of looking for a sanction as an incentive to do the right thing, there is a sanction because there is your reputation. And because the problem with the sanction is that honestly, the arbitrators never pay for their failure to disclose because it's not their award. They get paid their fees, and the parties usually pay for that as a practical matter for a specific case. But then you're talking about your reputation. So I see where you're going. And I do not disagree that I think the stakes have to be high when you're not disclosing. And I am in the OSMA camp that there is no such thing as over-disclosure. And if you think twice about a question, it means that you should probably disclose. I think that you should distinguish commercial and investor state. But in the investor state territory, I think as a matter of perception, if the kids of the council and that of the arbitrator go to the same school, good luck with defending that as a non-problematic issue. But it's purely perception, and we're talking at a political level. So that was the only sort of comment I wanted to give.
Thank you. I have a question that's quite a follow-up on that, because I think the problem that we have, and Mariana and Maria Claudia stressed that, is the lack of standard. If you don't have a standard, there's no such thing as, you have the standard, the subjective standard, but you don't have that much objective standard except for the IBA rules. But some of the Brazilian cases, they are challenged failures in some cases, in others no. In others are more meritorious, but others are not so much meritorious, and they are challenging things that are not at the IBA rules, or there would be green light at the IBA rules. So the question that so at the end of the day, and even this lawsuit, the lawsuit of the Brazilian Supreme Court, they are challenging whether or not the IBA rules are adequate in Brazil, because we're discussing things that are outside the IBA rules. So that's my question for the whole panel. Do you think that the IBA rules that are being revised right now suffice? Or we should have other standards, because at least in Brazil they're creating, they are the objective, they're being used as objective standards, but they are not working somehow, because things that are not there, like bringing things to school are not there, and they're being disclosed.
Do you want to? Oh, yeah.
I think very quickly on this, and then I'll let others speak. I think we need to be guided by, we have to be guided by general principles and standards and ideas. It's impossible. We'll never come up with a list. You'll never be able to say in a list that if your kid go to the same school as my kid, I have to disclose that, because we cannot foresee, as I was mentioning earlier, every single human relationship that people can have. it's just, we have to try to find a common ground. Are the IBA guidelines enough? I think they are now what they could be done at the time. That's why they're being revised. So let's see what's going to come out of that. But I do believe that we have, as I said earlier, a fair amount of indication, as what we should or should not disclose. And I don't think we will get much further than where we are, unfortunately, because of this impossibility for the nature of the discussion, for the nature of the relationships that are in cause. Obviously, if we're talking about relationships with counsel, with parties, or even amongst arbitrators, they are what not only the IBA guidelines already say, but the ICC now has their also little set of rules. All the institutions have their set of rules, but we will never get to a point in which we will have objective criteria in a list of this is what you have to disclose and this is what you don't have to disclose. Because as you said, we are starting to debate issues that we thought were in the green light and didn't have to be disclosed, and they are now giving rise to, serious debate. So at the end of the day, I don't think we will ever get to a point in which we know exactly what goes and what doesn't.
And just to get to a point, the issue of over-disclosure is that if you don't have a standard, each arbitrator discloses something. So if you are the chair and you disclose that the kids go to school,
will have to.
Then according to Celsius standards, I under-disclose it, and then what could be challenged. So that's a never-ending process.
Yeah. Oh, perfect. That's the problem of not having a standard. And I agree with Maria Claudia. I think it's undesirable to have a list of objective information that should be disclosed.
I think that's unrealistic. I think we have standards. I think it's good that we don't have standards.
I do. I think we have standards.
And they are supposed to be applied objectively. I think it's a problem that you can never apply. You cannot imagine all situations. My kids go to judo school and not English school. I mean, this is. I disagree that we don't have standards. We have clear standards, and then it's about to apply them. They are somewhat ambiguous, but that's also the point of disclosing, so people have a chance to investigate it with you and challenge with the relevant institution to clear that out.
Can I just jump in on this, because this is, I think, a broader question as to whether the traffic light system is appropriate going forward, and because it is supposed to be illustrative examples of things that may or may not warrant a challenge, a successful challenge in a particular case. But now we're seeing them as almost binding, as in, well, it's in the green list, so how could you possibly be successfully challenged? So it's almost perverting the purpose of those illustrative examples. And now if the example is not included in it, which were never meant to be exhaustive, it's, oh, well, you couldn't possibly be challenged. And we saw examples of that fairly recently. I think the Isa case was an example of, there wasn't a specific example of the relationship of Stanimir Alexandrov with the Brattle Group and working with experts in that way. It doesn't mean that the standard doesn't apply because the example is not there. So it'll be interesting to see if the IBA continues with the traffic light system, or whether it potentially cuts it back down or adjusts, something moves from green to orange, there's more of green, more of orange, but I would hope that it doesn't expand, because it almost plays into this trope that they suddenly become binding examples of what should not or should constitute a challenge that would be successful.
I'll just add to, I agree with Monty's. I think some of the informal relationships that might affect conflicts are not on the list that we're seeing. So for instance, which arbitrators like to sit with whom, and which arbitrators likely would appoint a presiding arbitrator because they're friends. And that affects the constitution of the tribunal, which we don't see in the guidelines. So not seeing there, does it mean it's fine? But these are real questions that we should be considering in terms of conflicts.
I'm in favor of an outcome-focused approach. I think lists can be too prescriptive, and then you end up debating the list and you lose sight of what is the actual issue that we are trying to achieve. So I'm very much in that camp.
Yeah, I agree. My point about standards is that we do have several rules, several principles, but the standard in each country nowadays is different. Otherwise, we wouldn't have this debate, at least in Brazil, about certain facts that are not clear. Should we disclose about the school of the kids or not? So the problem is what we are going to do with that. Is it enough to have just this set of rules, this set of principles and guidelines, or no? Or we need to have a more clear case law on this topic. Just to conclude, I think Manuel had a question.
Although I'm aware that we are running over time, so goods have to be of satisfactory quality, and no one really tears their hair because satisfactory is an open texture test. So we just need to get used to living with terms which are not necessarily so prescriptive. We just need to apply them. So I agree completely with your position. Now, one thing that has not fully been mentioned here is that what's the liability of arbitrators for the duty to disclose? Halliburton and Chaff is a massive case where parties in the end ended up with a massive cost bill in terms of the litigation, but nothing happened to the award, nothing happened to the arbitrator. If we have a duty to disclose, as we might have now, even on a statute with a review of the Arbitration Act, surely that's the enforcement gap that you mentioned at some point. That's something that might need to be considered. Yes, it comes together with perhaps having clear standards of what has to be disclosed if you're going to be held liable for failure to disclose. But that might help jump in the gap that might exist in the Brazilian legislation, in the sense that even if there is no annulment of the award because failure to disclose is not sufficient to set aside the award, surely the cost caused by that litigation around the challenge of the arbitrator or the challenge of the award, which could have been very well avoided if the arbitrator had disclosed that in the beginning, might be should be paid by the arbitrator herself.
Yeah, I mean, if your award is being challenged for lack of disclosure, and then the award is not set aside, and then the arbitrator still have to pay the costs, I don't know. I'm not sure. I think that then every single lawyer starting set-aside proceedings will always add a ground for lack of disclosure of something, and then at least get the costs at the end of the day, even if the award is not set aside.
Only if there is a conclusion that the tribunal should have disclosed.
But that's the issue. If the tribunal, I don't think the judges are there to say if tribunal should or not have disclosed. I think what judges need to look into is whether that arbitrator lacked in impartiality or lacked in independence. And if that's the end of the story, if they do decide that that arbitrator lacked in impartiality and independence, then yes, he should have disclosed. But the analysis, I mean, we are all talking about the disclosure, but the analysis here, in my point of view, should be, was the arbitrator independent and impartial at the end of the day? What are the circumstances that he did not disclose? Those circumstances really make him, fit to act as an arbitrator or not? And then you will, as a consequence, then say, yeah, okay, he should have disclosed. But then necessarily, you need a finding for the annulment of the award. I don't see a situation in which you can have an arbitration, have any kind of, liability when he didn't disclose something that did not annul the award at the end of the day.
But it costs a reasonable litigation as to whether that should have been disclosed or not.
It's complicated. What is a reasonable litigation that ends up with a finding that the award does not have to be set aside? I'm not sure. I think we're going a bit too far here, and I think we should be focusing on the real issue of whether people sitting as arbitrators are impartial, are independent, and the disclosure is the tool, one more tool for us to try to give the parties all the information they need to reach that decision. But at the end of the day, for me, that is the real question: was that person fit to serve as an arbitrator in that case? Because she or he did not have any relationships that would, put that into question.
I want to thank you. Unfortunately, we are running out of time, and I want to thank you, all the speakers, for the brilliant and productive discussion, and for the participants and thank you for the organizer once again. And so see you.